Now you know that this arbitration agreement is important, and this is prerequisite to start any arbitration. Now, what are the importance of arbitration? Basically, see, in any corporate, if you're signing any corporate deal or making any contract, usually what happened before Arbitration Act came into picture, Arbitration Conciliation Act came into picture. What happened that you need to go to the court, right? You must have studied the contract. Now, violation of the contract or infringement will lead to the proceeding in the court, and in court it usually take minimum of 5, 10 years or even 20 years to conclude the case. Now, in this arbitration, the maximum time that is granted to arbitrator is 1 year. To the maximum extension of 6 more months, which will lead to 18 months. After 18 months, the party will, there is no time extension. So they have to report in the court and they have to give the arbitrator have to give the reason for delay and so on. So, mentioning which we hereby conclude, we can easily conclude that arbitration is a process for the solution of the dispute between two consenting parties who sign their arbitration agreement, and based on their agreement, they resolve the dispute amicably through arbitrators. And once the arbitrator are appointed, right, they cannot be obviously they can be terminated if both the party has the consent, but they cannot be terminated otherwise. Right. You need to conclude the case, or both the party had to agree on it. One independent party cannot terminate the arbitrator once they are appointed. However, if they are not appointed, the matter is in case. Now, talking about arbitration agreement, right? So, when you read this Arbitration Conciliation Act, I won't go into details so much as that you won't be able to understand entire arbitration. I'll give you certain liners, certain point details that you can grasp and understand the arbitration process, also international commercial arbitration, New York Convention, Geneva Convention, and how actually arbitration takes place. This class will give you idea on whether you should recommend your parties to go for arbitration or not, and if the matter is of arbitration, how to go ahead. However, you may need a detailed class with 20 50 lectures, so as to make a good understanding or arguments and conciliation, mediation, and so on. Right. So, first, importance of arbitration agreement. Why this arbitration agreement is important? As per section 7, arbitration agreement has to be signed by both the parties. That is clear, right? And it should be written only. These two things are clear, right? Now, there must be arbitration agreement so as to proceed for arbitration, right? And only when you have arbitration agreement, you can take the remedy that is there in section 8, which where under you can visit the court so as for appointment of arbitrator. Now, once the arbitrator are appointed, obviously they will constitute arbiter panel, arbiter union, and thereafter you are proceeding under section 24, 3, section 24, 25 will go on. That is entirely a different process. Now, what makes up arbitration agreement? Yesterday only I have read Delhi High Court judgment which says that even if the party have certain communication through WhatsApp and they have agreed to do it, that will constitute arbitration agreement. Agree to it means what? In section 7 itself, if you see, you may open the section 7 on a mobile or so, or if you have arbitration conciliation act, you may open it there as well. You see that it asks for that both the parties would have the conversation with each other, either in the form of telegram or so and so and so. So in there, the Delhi High Court has interpreted so much as to include WhatsApp communication or email communication also, wherein the party has to expressly accept the power of the compliances of arbitral tribunal, right? It should not be implied; it must be expressed. Now, drafting of arbitration agreement. Ideally, these circumstances does not exist. I mean, these are the exceptions where you make conversation on WhatsApp and same is taken for in the furtherance of arbitration panel or arbitration. Usually, what happens is that party sign a express, a detailed agreement which we call arbitration agreement, and it should have all the details, including all the all the details means we'll talk about following points. First, that if there is to be a resolution of dispute, it has to be at some place under some jurisdiction, right? Am I being understood? If there will be a resolution of dispute, there must have to be a place, like somewhere that is Delhi, Kolkata, so and so and so, right? So this place is important. Right? Place is important in reference to what? Since in the panel of arbitration, you don't have to actually visit the court. You can resolve the dispute sitting in your home or online, just like the way we are talking. You can do likewise also. So why place is important? Why? What is the importance of place in the matter of arbitration agreement? Anyone? Anyone like to answer? May proceed. Otherwise, I will obviously explain why place is important here in the arbitration agreement. Try your guesswork.
It states that where arbitration will take place.
Right, Pragati. But as I mentioned, that arbitration can take place online as well. Right. I can be in Bangalore. I can be in Kolkata. I can be in any country as well. Mauritius, Sri Lanka, any country. I can be there and conduct the arbitration procedure. I don't have to be at a place. I don't have to be present at the place. So why it is important for arbitration agreement to have a place expressly mentioned in the agreement. There is a point before it, and that's very important point. Let's say in a civil dispute, I'll give you example. Let's say I had a contract with government of India for let's say construction of road or construction of a metro or anything like that, and there's some violation of my part, let's say, or the on the part of government. Right? We may conclude that if the matter goes to the court, we have to we both either representative of the government, so through attorney general or maybe assistant public prosecutor, right? They have to be there in the court, and me either through me directly through me or through my advocates have to be there in the court. Right? But which court? There are, I mean, some 600 courts in India and 28 high courts, one Supreme Court. So which court? Which court do I have to be present there? Right? That will be decided by jurisdiction. That actually where did the offense or where did civil liability took place? First thing, second thing. That in these days the matter is not as simple as that. Let's say you're making an online transaction and the company, the let's say Flipkart is situated in Bangalore and you are making transaction from let's say Chandigarh. So what would be the place of dispute? Whether it be Bangalore, whether it be Chandigarh, either can be a place of dispute. But let's say if you are a in a mobile business, mobile means transport business, and you don't have a particular office, however there is a breach. So the last case in which you were situated, right? These are as per CPC guidelines. These are as per order 1 to order 5. If you read, you will get it. Entire thing is there. Or and section 2 or 25. All these things has been mentioned in CPC. Now, this jurisdiction is important for the purpose of arbitration as well, right? Let's say in the matter of arbitration, as I've said that I don't have to present on the place physically, but even the matter of arbitration goes to the court. As per section 9, you can go to court for interim relief. As per section 17, you can obviously go to arbitration for it. When the parties are not going to comply with the arbitration award, they will be visiting the court. Now, which court? That court will be decided based on jurisdiction only, right? Eh, That will be district court, obviously, but that district court will be decided based on the jurisdiction only. So the place that we mention in the arbitration agreement, we do that so as to decide on the jurisdiction of the court. That which court, which part of the country will have jurisdiction on this matter. Do you get it? It's clear, right? Is it clear? Right. I'll share my screen. Let me know if that's visible. It's visible, right?
Yes, sir.
All right. Okay. So you see, this is simple arbitration agreement. We'll start with the name of the company, obviously, and this is agreement comply with the contract draft as well. So in the contract, you see both the parties, you mentioned both the parties against whom you actually, who is actually filing the case. Now this in arbitration and the contract also, there is no difference up till here. That you cover that what all will be covered under this arbitration agreement, and for this we want to make arbitration agreement as exhaustive as possible, right? Which means that we want to include all of those things that could have been included or that we want to include. There is nothing inclusive in this matter, right? You can, if you write etc, or if you assume that contract arises out of contract will be part of arbitration agreement, that is not going to happen in arbitration agreement. You have to specifically mention this. You have to specifically talk about this in your contract, and then and there only we will be able to proceed with it. Right. You have to be as express as possible. Right. Second thing is that resolution of claims exclusive method. All claim must be resolved according to the procedure under this agreement. So and so. Right. In this, you write I'll say this draft and some other draft that will be ideal for you on drafting arbitration process. Right. So here you mention the jurisdiction or the matter which will directly go to arbitration. Right. Those matter which arises out of the contract will also be part of this contract if you have mentioned it. But that is important for you to mention it in the contract itself. In the grievance procedure, obviously, we will provide arbitration, and with this comes the entire thing in place. Like now, let's say that you have signed the arbitration agreement and you have mentioned the place of arbitration itself. You have mentioned, let's say, Kolkata is the place of arbitration, which means that in Kolkata there will be High Court as well, there will be District Court as well, right? So the District Court of Kolkata, let's say Zone A, will be will have the jurisdiction on this matter. Now, after this, you need to decide arbitrators. Either you are going to decide the arbitrator at that very point, right? At that very point, you are going to decide that who will be the arbitrator and both the parties have to agree to it, or you will be enlisting the procedure through which you will be appointing the arbitrator, right? Let's say there's a dispute. Upon dispute, you will visit the court, and after that, court, how arbitrator will be decided. So there can be two arbitration here, two kinds of arbitration here. One is called ad hoc arbitration, and other is called institutional arbitration. Right. What is ad hoc arbitration? Ad hoc arbitration is the arbitration where you yourself or your party, both of it, decide entire procedure of the arbitration, and they don't need any institution or anyone else to play or any role in it. What is institutional arbitration? There is a set of panel, let's say all the top tier firms nowadays come up with the institutional arbitration setup where if one of the party or both the party have any dispute, all they have to say that Khaitan or Co or Amarshil Mangaldas and Co will be handling this issue. All or any other law firms will be handling this issue and they will set up the procedure. Right. So if you agree on it, there will be separate arbitration procedure. There will be separate, the institution will make you sign their documents, and they will themselves decide the entire procedure and let you, they will discuss the procedure with you and sign the document with you. Right. So there's two kinds of arbitration here you have understood. Like one is ad hoc arbitration and another is institutional arbitration. Am I understood? Perfect. Okay. Now, once you have decided the a panel of arbitrators, and once you have decided the, whether it should be ad hoc arbitration or whether it should be institutional arbitration, you are to decide the procedure of arbitrator. Right? Procedure of arbitrator. Now, procedure of arbitrator is also there in section 11, section 12, and whatnot. All this arbitration constitution that talks about it. So why do you need it in your contract? Why, even if, see, this act has the procedure, how to conduct the arbitration, how arbitration will be conducted, that's also there in the act, section 23, 24, 25, 26, and so on until section 31. About how arbitrator will be formed apart from section 7, section 8 to section 22. Right? Now, arbitration agreement that is there in section 7. So everything is there in the act. Why do we need to discuss about procedure here? Because a contract act is a private, the contract that you're signing, when two parties are signing the contract, that contract becomes an act for both the parties. The contract becomes a law for both the parties. Both the parties will be, abide by it. They have to accept each and everything that they they have signed about it. Right. So if you've not signed about any procedure, if you are confused about any procedure or have not signed it, the procedure does not exist even if that is there in the act. Now let's say you want to make a draft that will create less of chaos, less of friction, and more of a situation where a dispute can be resolved. You probably notice that when the parties are at default, let's say we both are signing the agreement, and let's say I'm at the default. Defaulting party will always want to make some way or other way out of the legal, procedure. If not, if they cannot sort the case, if they cannot turn the case, they will want to delay the case. They will want to delay the case. Now, sometimes this delay acts in their favor, right? So as to avoid this friction, so as to avoid this delay, we come up with, as much procedure or as much input that we can put in our arbitration agreement. We want to do that. Why? Because this will lessen the friction, this will lessen the confusion between the parties, and will straight away go for something that is solid, right? So this is the philosophy behind it. Arbitration procedure, obviously, section 23 talks about it. What is settling? Am I audible now?
Yes, sir, you are audible, but your voice is not clear, sir. I mean, getting with noise, sir.
Getting with noise. Is it clear?
Mhm.
Okay, all right. So in the arbitration procedure, what we try to solve is first thing that where the arbitration will be conducted. See, there are two things here when I talk about place of arbitration that we have discussed. That place of arbitration is directly situated with jurisdiction of the court. Now there is two things: place of arbitration and there is venue of arbitration. So what is place of arbitration and venue of arbitration? Let's say if you are not, if you're not living in India, or let's say even if you're living in India, you are not in Kolkata and the form which you're signing is there in Kolkata. So what you'll be doing that will be will if both the party consent to it, will make Kolkata as the place of arbitration, which means that District Court of Kolkata will have direct jurisdiction and High Court of Kolkata will have direct jurisdiction over this matter. Now, if you are not resident of Kolkata and if you're living in Bangalore, so why you always want that Bangalore should be a suitable place of arbitration? And other party, let's say, is also living nearby Bangalore in Bangalore, right? So Bangalore can be a venue of arbitration, and this can be venue of arbitration can be anywhere in this world. It can be America, Switzerland, Mauritius, anywhere in this world. Right? So, for your understanding, place of arbitration and venue, VNUE, venue of arbitration is not the same place, not the same thing. They are two different things, right? When you make a certain place, certain district as a place of arbitration, venue of arbitration, if you want, you can keep that also. You can keep a different venue also, right? So the first thing that you are deciding here is that place of arbitration, the venue of arbitration. Second thing that you are deciding that how arbitrator will be appointed. Either you have a pre occupied notion that you want to appoint someone as arbitrator, or if you want to enlist the procedure that once the dispute will commence, both the party will choose their own arbitrator, and the chosen arbitrator will choose one arbitrator that is called presiding arbitrator. This situation is there in section 11, just that you have to mention it in your clause so that there is no confusion. And once you have decided arbitrators, then you will be deciding how arbitration will commence. And how the arbitration will commence, that both the party will present the case before the court, before the tribunal, and arbitral based on the written or oral or written and oral proceedings will decide the case. So that you have to mention in your arbitration agreement, right? Let's say if you are not an Indian resident, let's say if you are a, which is I don't think that anyone here is not an Indian resident. But if that is the situation, you can, let's say if some of you are living in USA and other one is living in India, so you can decide that which law will follow in this case, in this arbitration agreement. Like there may be a situation where after doing law or in the time of your advocacy, you may come to the client and the client is let's say USA resident. So you, in that particular clause only, you will enlist that which law will apply. Indian law will apply or the USA law will apply. What will be the jurisdiction of the matter? Now, cost of arbitration will be decided in the arbitration agreement itself, that who will be bearing the cost. If you are to say that the winning party will be bearing the cost or losing party will be bearing the cost, That is the matter of your decision. Whatever is decided, or both the party equally bear the cost. Whatever is decided, that will prevail. Right? Whatever is decided here cannot be disputed further in any proceeding of the court. So whatever is decided in the arbitration agreement is very important. Legal representative obviously will LRs are one who will survive after once that. So that will be there. No employment contract is not necessary. Severability is necessary. That this arbitration agreement will have exclusive jurisdiction, and the arbitrators can decide upon the survival of this agreement. So this is the doctrine of severability, that this arbitration agreement and validation of this contract is are two different things. So that will be that will be covered in this arbitration agreement itself. Governing law I have already discussed, and successor, successor and assign. If you want to, you can proceed with that. Now I'll be sharing in the proceeding. We have discussed following thing. First thing, arbitration agreement. That what is arbitrators? What are arbitrators? How agreement is formed? What are the essential of arbitration agreement? Right. And what after arbitration agreement? Let's say you have signed the arbitration agreement with both the parties. So what after that? You'll proceed to the court. Now, who will have jurisdiction? Let's say the arbitral award has been pronounced. So can you appeal against this arbitral award? Right. So answer to that is that the arbitral award cannot be appealed. Right. It can only be set aside. And for that matter also, arbitration agreement is becomes a very important ingredient. Now we'll see about how drafting comments here. So I prepared this PPT from the very basic, that what is drafting and how was to proceed with it. Right. Drafting basically is an art where you, as a litigant or a researcher, go through particulars of the parties, particulars of the documents, and decide based on the LORs, like uh, LOI, letter of intent. Right. What is letter of intent? Letter of intent is basically, am I audible?
Yes, sir.
All right. So what is letter of intent? Before going for before going for the final contract or final agreement, you ask both the parties that how you want to proceed with the case. What are the important ingredients? What is important for one party may not be important for the other party. So they give you the list of it. Right. There are certain points that are important. Let's say about talking about the arbitration agreement, talking about the arbitrator will be appointed. Let's say you have a reservation that people from judiciary shall be your arbitrator. Now, other party has a reservation that it will cost high. So, people from any background can be arbitrator. So, these are the important things that you discussed for both the parties, so as to come with complete draft. Right. So drafting can obviously take place in many documents, legal documents. That can be legislation, that can be legal documents, that can be rules, regulations, and so on. Right. Certain prerequisite that you must have, that you must have clear picture of the case. right? You must have a legal fact in your mind, and you shall avoid all the ambiguity and the doubt that can be there in the contract. And once you have a clear picture of both the parties, you go for, uh, in this case, particularly going for arbitration agreement. Now, as I have discussed that first you need to have to take the consent of both the parties, which is called planning stage. At this planning stage, you ask for letter of intent. Thereafter comes the writing stage that we have discussed in the through the draft. That in the writing stage, you enlist both the parties, and this party, once you have placed both the party, you decide upon the place, and then you decide about what all will be covered, and you decide about the liabilities, you decide about the cost of who will be paying the cost of arbitration, what would be the jurisdiction, whether there is severability agreement or not, whether there is a particular obedience of contract or not, and what are the particular remedies, how much are the party will be, how much will be the party paying once they have repudiated the contract or once they are not followed the contract. Everything, entire thing will be decided here, and then you'll go for revision. Once the revision is done, you'll present the draft to your, to the one who have assigned. Now, drafting of arbitration clause. Right? So, arbitration, you know that it is a process of ADR, which is basically outside settlement of the case. So, while discussing arbitration clause, you must mention before the in your agreement that first, when the arbitration will take place. Second, where the arbitration will take place. Third, how the arbitration will take place. And before whom a dispute will be arbitrated. These four ingredients are very important in when you're construing arbitration agreement, right? And to construe this arbitration agreement, what I'll do that I'll send you assignment based on the draft that I'll be sharing, and you need to submit this assignment, right? By how much time? If I'll give you the assignment, how much time will you take to submit it back? How much time do you want to submit the assignment?
By Monday, sir.
What, 1 month?
No, by Monday.
By Monday? Yeah, clearly today is what, Friday, right? So Monday would be good. Everyone agree to it, right? Everyone is in agreement, right? You can submit the assignment by Monday. And once you see, it's very important that you submit the assignment, because otherwise this would be any class as theoretical class, and don't want this class to be theoretical class. I want you to actually learn the craft of drafting. So this will, I mean, see, talking about cricket, watching cricket won't make you a cricketer. Any game, let's say boxing or anything, you need to practice it on the field, right? You agree, right? You need to practice it on the field, and then you have to make mistake. You have to do things that is required there. And once you are guided by the mentor, and then you actually, make some changes, actually improve your craft, right? Otherwise, it would be just any other lecture that can be there. Right. So what I basically want here is that I'll be sharing a draft agreement, and I'll be sharing a situation, right? And based on this situation, you have to draft an agreement, arbitration agreement, and this is to be signed by both the parties. Right. So there are lots of module. I don't believe that I'll be able to complete in time. All right. So common element of arbitration agreement that we should remember is that first of all, this arbitration agreement is a binding decision, And this arbitration agreement is going to cover all the dispute that will arise from this contract, or if you want to mention a certain specific dispute, a certain specific dispute can be covered under this contract. This is important that when you mention what kind of dispute are you able are you going to resolve between the parties, right? Third thing that there will be an arbitrator. There can be the arbitrator will always be in odd number only, right? One, three, five, seven, nine, whatever it is, odd number only, right? So you decide the number of arbitrator then and there only, right? You mentioning it down, right? Then we'll discuss that how arbitration proceeding will take place, and you also discuss the language of the arbitration agreement and language of arbitration proceeding. And this arbitration agreement will be signed by both parties. Only then it will become an arbitration agreement. So these are five elements which makes up in totality arbitration agreement. This has to be done. Now, let's say you have a international parties, so you have to mention the specific jurisdiction in which you want to resolve your case, and if you want that arbitrator will be selected by institutional arbitration, so that should be in there. Right. Creating a standard clause. What is standard clause? That is, it is exhaustive of everything and it cover almost everything. Right. The parties are free to, if you, it is not important always to enlist everything there in the clause. Sometimes it becomes important for parties to decide that what should be included in the arbitration agreement and that should be complied with. That this we have also already discussed that there are certain things that we should keep in mind. These five things that we have discussed. First about appointing the place of arbitration. Second that who will be arbitrator. Right. So this we have discussed. We won't be making any repetition, and I want to share you a case that you need to work upon. Right. So case is that it is between ONGC. Okay, if I mention the company, then we will start with that. It won't do any good. Let's assume a situation between, you know, how do I say it? Yeah. So there is a situation where you need to open a coaching tutorial in Lucknow, right? The first party is ABC, second party is XYZ, right? And you need to open a coaching tutorial in the district of Lucknow. Now, you people have agreed that there'll be 30% fee. ABC is a company who will be teaching law classes, and since they'll be teaching, they'll be handling the teachers, they'll be handling admission. They will take 50%, 70% of the revenue. And since XYZ is owner of the land, and it will provide you with all the accommodation facilities and electricity and everything, whatever comes there. So it will take 30% of the revenue that is generated. Right? Based on it, they create an arbitration agreement between both the parties. where one party is ABC and other party is XYZ. Right? You need to create an arbitration agreement, and in next class we'll discuss that how arbitration proceeding is conducted, how arbitration issues are concluded, and what is New York Convention, Geneva Convention, and how the things take place. Right?
Sir, if
Can
you
you
can
submit it
put, sir, if you can put the oral question in written form, it will be helpful.
chat format?
Yeah.
Okay, I'll do a thing. After this class, no, I'll ask admin to send you a message in the group, and in the group itself, we'll be having these details. Okay, so it would be great if you can submit this assignment by Sunday night or Monday morning, so that I may go through it in between, and by 7 p.m. I'll be able to take few agreements in picture and suggest any improvement if there is, and take the class also.
So can you explain or re-explain the concept of venue and the place of the sitting?
Venue and place of arbitration.
Hmm.
All right. Also, in this, while we're creating arbitration agreement, be as creative as possible, because not all the fields that is important I have mentioned. So be as creative as possible and uh, frame your agreement based on the simple file that I'll be sending. Now, venue. Venue can be any place in this entire world from where you actually want to conduct your arbitration. Let's say if you are living in Bangalore and other party is living in Hyderabad, but you know that you want to submit to the jurisdiction of Calcutta District Court and High Court. So the Kolkata can be your place of arbitration, which you visit occasionally, as let's say your company is also there. So Kolkata can be a place of arbitration, and venue can be the place where from where you actually, let's say Switzerland. So you can also uh, fight a case or solve a dispute from Switzerland also, right? Venue can be any place from where you are actually handling the arbitration matter, and the place of arbitration or seat of arbitration is just place in which jurisdiction you want to follow.
Okay, sir.
Any questions? Any further questions?
Yes, sir. So can I,
Please.
sir?
Yeah, please.
So once arbitration, I mean, for example, between A and B, so they approached arbitration. So and the arbitration, got favorable to A, and agreed party B can able to challenge this arbitration into the higher courts.
Yes, arbitration matter can be challenged, but see, once you have the arbitration award, right? Arbitration award once signed by both the the majority of arbitrators. Arbitration award once signed by majority of arbitrators will become binding according to Section 31. Right? It will become binding on both the parties. Now, you cannot appeal this arbitration award. You can only say the same. Meaning, in Section 34, it is mentioned that what are the ingredients in which we set aside. Set aside means that it is null and void. So either you are declaring the arbitration award null and void and proceeding with the court, or either you are accepting the award and proceeding with the execution of it. Right? You cannot appeal it. The question was that whether you could visit High Court. Obviously, you can visit District Court. Uh, High Court is eliminated in this process and direct to Supreme Court. Right? Uh, but it should be clear with you that you are not visiting the court so as to appeal the award, but to set aside.
Okay, how can we find the arbitration center, sir? For example, I have
How can
panels.
how can we? I miss that. How can we
Identify the arbitration centers.
arbitration centers?
Yeah,
See, each high court, this is must, according to section
sir. We lost your voice, sir.
right? But you will be not visiting this arbitral institution. It has different purpose to serve. See, arbitral tribunal can be constituted by a private party itself. Let's say I and you are a party. So we can ourselves create an arbitration tribunal that will have banks. Right. Thing is that once we have created this, say,
Sir, your
while
voice is
entering
break.
into a contract, am I audible now?
Yeah, now okay, sir. But middle of the your voice is breaking, sir.
All right. So let's say we have signed a contract.
Hmm.
Right. Now, when signing a contract, we want that if there is any dispute or if there is any matter with the contract, we'll proceed with the
Sir,
right.
still will your voice.
Now, we say site. Is it unclear to everyone or just 1 2%?
Sir, sometimes your video gets stuck.
It will keep pausing. Okay. Let me use my data sets. Sometimes there is problem. Hello, am I audible to everyone?
Yes, sir. Yes, sir. Right now, okay, sir.
Is better?
Yeah, yeah, sir.
All right. All right. So I was saying that let's say we have formed a contract, and in contract, if there is any dispute, obviously we'll go for arbitration. Now, when we are constituting this arbitration panel, we'll decide that who will be arbitrators, right? And once we have decided, as I said, that arbitrator, according to section 10, that arbitrator can only be in odd number. So that is mandatory from that. But who can be arbitrator? That is not mandatory from that. You can choose any, literally anyone, anyone. It doesn't have to be advocate. It doesn't have to be judges or any particular person. You can choose anyone as arbitrator for our cause. You can also choose sole arbitrator. Let's say we both have selected our teacher as a sole arbitrator. Now he will have all the power so as to declare an arbitral award. Right? So there can be chances that arbitrator can be biased and it has not come up with proper due diligence. So for that purpose only there is section 34 in which there is certain procedure, right? Whether notice has sent to both the party, whether the award was fundamentally against the policy of India, whether it suffers patent illegality. There are certain procedure declared section 34, according to which if the procedure not followed, the award will be declared void.
Okay. Sir, for example, so I'm a practicing advocate, so I have a more than 15 or 20 years experience. So I'm an individual person. So can I get a license for arbitration purpose? So where we need to get that license and how I become a arbitrator?
It's Arbitration Council of India, right? You can obviously create your own arbitral institution, right? First, try and understand these two things very clearly. One thing is that party can create ad hoc arbitration. For that, they doesn't need any institution to participate. However, they have to take there's a lengthy procedure that will be followed. Arbitration matters are very serious, and among the big parties are into the arbitration because it's costly affair. For the section who is not who want to solve the dispute at the very affordable price or at no price, there is another dispute resolution mechanism that is called legal aid. Might be aware. National Legal Service Authority, State Legal Service Authority, right? You might have heard of it. Legal aid programs. So that is cheapest legal procedure in that the law has invented. Now, arbitration is the costliest legal procedure or dispute resolution mechanism that the law has invented. These two divergent routes are clear to you, right? Now, in this road also, in the arbitration also, there's two divergent route. One, we call it ad hoc arbitration, right? We both are the party. We can create our own pen and all procedure, everything, and be the arbitration for that. That is quite in the arbitration also. This is the cheapest form of arbitration. Now, see, we both are into our daily life. Let's say you represent Larsen and Toubro, I represent Reliance. So we have a busy schedule, we have a busy life, and some lax doesn't matter to us. So we can go to some law firm, right? All the companies like this go to law firm, and they can ask the law firm to conduct the arbitral proceeding on their behalf, and whatever will be the award, both the party will abide by it. Right. So then the parties approach arbitral institution. For to have an arbitration institution, you should have two things. First, approval from Arbitration Council of India. Second, be recognized by the respective high courts, right? So once you create first to create arbitral institution, you must send uh, the place of business, your registration number, panel of advocates, everything to Arbitration Council of India, and this is available on their website. You can check it out.
Okay, sir. When we are making any contract, I mean, for example, so I'm a SRM university, so I'm making a contract with, for example, whoever contractor, so to supply the materials to SRM university. So in that case, so should I need to mention, so any dispute occurs, so primarily we need to prefer arbitration rather than we need to prefer the court. So that is need to be mentioned in the agreements or not, so that is mandatory or not, so
See, arbitration, as far as I have understood your question, in arbitration only those matter goes which have clear arbitration agreement in the picture. Right? So if you have any dispute or if you want a particular dispute to fall under the ambit of arbitration, you need to keep them under the arbitration clause. Only then you can ask for a remedy under section.
okay, okay. Yeah, yes, sir, thank you very much, sir. That's it, sir, from my end. Yeah.
Anyone having any other questions?
So, what are the common mistakes that people tend to make while drafting a arbitration
That you will
agreement?
see.
So that
That
we
you will see
also
when you draft your arbitration agreement, the assignment which I have given you. And that you will see that what mistake have you made and how you could have avoided it. First, uh, lack of time, right? Because in real world, when you enter into advocacy or you take the matter of arbitration, you have so much of case. First, in first few days or first few years, you have no case to work upon, and then you have lot of time in first few years. After few years, you have so much of case that you don't have a particular time to devote it, right? And then this lack of time makes your work more complicated than ever. First mistake that coming to picture. Second mistake that we take for granted the consent of the parties, the need of the parties. We say that since we are a legal expert, we can do it ourselves. But it is not that we are solving our case here. We are solving this case for the party, and with the authority of that party, right? So in this case, even if we are the legal expert, we need to take all the advice, suggestions, and recommendations that the party want to deal with, that the party want to impose on us, and we are just the all the middleman won't be a right word. Advocate, as an advocate, we are a representative of them in the court or to resolve the dispute. So often we take for granted and we become justice giver. Advocates are not meant to be a justice giver. We are not justice ourselves, and neither are the justice. The main concern of judge is not to deliver the just decision. Their main concern is to judge the case not only on the just but equity and good conscience also, and to follow the law that is there. Right. So second mistake that we make is that we ourselves become expert, or at least we think that we're expert, and ignore the consent or the approval of the parties. Right. Third mistake that we make is that we generalize the opinion. See, as an advocate, we'll be taking 30, 40 cases on a monthly basis or on a daily basis. Right. Once you are senior advocate, you'll be taking hundreds of cases on a daily basis, and you yourself going to litigate only one or two cases on a daily basis, not more than that. It takes lots of energy to deal with case, right? With so much of enthusiasm, right? So we generalize the case. We have made hundreds of arbitration agreements. What we do is that we copy it from there and paste it over there. We generalize this. See, each legal dispute has its own merit and demerit, its own lacunas, and it has to be dealt likewise, right? So generalization is not a thing in the law, right? We're not writing a research paper where we can put on the opinion and that will be followed somewhere or other across the country or across the international community. We are dealing with a particular party who have paid us. Obviously, their matter will be much different than the other, right? So, fourth mistake that we make is we generalize the mistake. Now, fifth mistake becomes very dangerous is the ignorance. We know everything and yet we fail to comply with certain sections, certain recommendations because of any of the above four, either lack of time, lack of knowledge, or generalization, or of expert. All right, am I understood?
Yes, sir.
Any further questions?
Sir, final one, sir. Can I ask, sir?
Please, please.
If one party agrees to come for arbitration, so but opposite party not agreed to come for arbitration, so in that case, what we need to do, sir?
See, that is why I said that Section 7 is mandatory, which means that both the party have already signed the agreement to come for arbitration. So, if after signing the agreement, one party is not proceeding with the arbitration, you just have to follow the procedure, right? What you have to do, you have to send them legal notice, right? You have to send them legal notice and proceed
Mhm.
ex
Okay.
parte, which means that there will be unilateral arbitration.
Yes,
That
sir.
is there in Section 4.
Mhm. Mhm. Okay. Yeah, that's it, sir. Thank you, sir.
Okay, thank you everyone for taking the class and taking so much interest in asking the question. I'll take some time in sending assignment. I'll be sending by tonight, and I expect your positive, submission by Sunday night or maybe Monday morning, so that I may work on your assignment, at least see it, go through it, and let you know if there is any changes, recommendations, suggestions, and if I can be of any help in improving your craft in the draft. Thank you.